There's two ways to be charged with a felony DUI. One is after your fourth DUI in 10 years, 4 or more, you'll be charged with a felony. But the second way is that if somebody is DUI and causes injury, they're going to be charged with Vehicle Code Section 23153, which is DUI causing injury. It's typically charged, or the person is arrested for a felony, but really what it is it's a wobbler. It can be charged as a misdemeanor or a felony. There's several factors that are going to decide that. One is the level of the BAC, or blood alcohol concentration, in the person's system. The higher it is, the more likely they are to charge a felony. Another factor is the type of driving that was observed, that led to the accident. How reckless was it? If it was very reckless, likely a felony. But the next two are the biggest factors. One is, was there a previous DUI? If there was a previous DUI, if somebody was on probation for DUI, or they had a previous DUI on their record and they've now been in an accident that injured somebody, it's almost most certainly going to be charged as a felony DUI. And the second one is the extent of the injury. If somebody is they suffer from soft tissue damage, because a lot of people that get in accidents, they go run to an attorney, try to get money, and soft tissue means kind of nothing shows up on the MRIs, and it's just kind of what you're claiming. There's those kind of injuries, could be maybe not charged as a felony, maybe it'll be charged as a misdemeanor, or you could certainly get it reduced to a misdemeanor. The injuries are, more serious, like there's blood, there's stitches. That could be charged as a felony DUI, and it probably will. And additionally, if they're even more serious than that, broken bones or something substantial, could be charged with a great bodily injury enhancement pursuant to Penal Code 1222.7, and that would up your exposure. A simple felony DUI with injury, you go to prison for 16 months, 2 years, or 3 years. Well, if somebody is harmed with great bodily injury, then you could face an additional 3 years in prison. But one of the most important things to realize in a DUI case is that it's not just that you have to be driving while you're under the influence, but your driving has to be the cause of the injuries in question. And a lot of times, almost every time that I've seen, when somebody is driving under the influence, they always attribute to the cause of the accident to that person. But it might not be the case, and a lot of times it's not. For instance, if I'm driving my car and I'm under the influence, here's an obvious case, and somebody rear ends me, and I've had a few drinks and my blood alcohol level is above 0.08, I'm technically DUI. That person who rear-ended me, though he may have been injured, triggering a potential DUI with injury, a felony DUI, I didn't cause the injury just because I was DUI. My being DUI had nothing to do with the injury. And so in a lot of cases, when you kind of zoom in on the details, as they say, the devil's in the details, you see that the causation issue is gray and it doesn't really fit the picture, and it's hard to prove beyond a reasonable doubt. So when it comes to a DUI with injury, hire a good attorney to defend you.